thank you for joining us. My name is Katie Perez, and I'm a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the L-1 and the EB-1C visa options. But just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including an F1, a TN, B, and an H1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5s, and extraordinary ability visas, and more. We will continue this webinar series, doing at least 2 webinars a week on different topics, and at the end of this webinar, we will send out several useful tools. So we will send you a copy of the PowerPoint presentation from today. We'll also send you a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. So this webinar will be recorded and it will be available on YouTube. We'll also send you a link for that. We do encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange for a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. So if you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. So today I will be presenting the first half of the webinar, and my background does include 10 years of experience at USCIS, where I did adjudicate the L petitions. We are also joined by Kelly Weiner. Kelly is a partner here at Scott Legal PC and has extensive experience processing employment-based visas to include the L1 and the EB-1Cs. She has also helped many clients successfully obtain these visa classifications. So without further ado, we will get started. Okay, so first we'll just go over what is the L1 visa. So the L1 visa is a temporary non-immigrant work visa that allows a company to transfer certain qualified employees serving in a managerial, executive, or specialized knowledge role from one of their foreign offices to a related office here in the United States. So there must be a qualifying relationship between these foreign and U.S. companies. The qualifying relationship must be that of a parent, subsidiary, affiliate, or branch. And the non-immigrant classifications for this section of law are the L1A and the L1B. So the L1 visa can be an option for a company who has been doing business in the United States for an extended period of time, at least 1 year or more, and they want to send that qualified individual over here to work. However, it can also be an option for companies that have never done business here in the United States, but they're looking to grow their business here. So companies who have not been doing business for more than 1 year would be applying for something called a new office. And then a new office is specifically defined as something, as an organization that has been doing business here in the United States through an organization for less than 1 year. So both the L1A and the L1B petitions can be filed as new offices. So the L1 visa requirements, we'll discuss just a little bit more in depth the specific requirements. So when an employer does wish to transfer an employee of the foreign company to a U.S. company as the L1 non-immigrant, they must demonstrate in part that the companies do have what is called the qualifying relationship. So the qualifying relationship is a very big piece of the petition and a very important part of it. So again, these types of qualifications can include the parent, affiliate, branches, or subsidiaries. In here, before you do file your petition, it is really important to look at how the companies are related to each other, because within immigration, there are very specific definitions for the relationships for each type. So you would want to look at how both companies, the foreign company and the U.S. company, are owned and controlled. Both parts are very important, specifically the ownership and how they are controlled. And then many times people do think they understand the relationship between the foreign and U.S. companies, but again, immigration does have a very specific definition for the type of relationship, so you do need to look at those documents. Um, as an example, you might have company X that's owned by three people, um, A, B, and C. Then you might have company Z over here in the United States that's also owned by A and B, but also by D, a different person. So although each company might be owned in equal shares by those people, they would not actually be classified as what you might think is an affiliate, based on those same owners, that they both have two of the same owners, for immigration purposes. So, although they do have a majority of the same ownership, that would not qualify for the affiliate relationship just on those very basic facts. So again, it is just really important to do an analysis of the relationship between the U.S. and foreign companies before you file that petition. So you must also show that the foreign and U.S. companies are both doing business on an ongoing basis. Doing business also does have a specific definition. So doing business is defined as the regular, systematic, and continuous provision of goods and or services. So you would need to show that both companies are actively doing business, that they're actively trading. So typical evidence for this requirement would include something like your taxes. You could provide financial statements, your bank statements, or invoices. Something like that usually satisfies this requirement. There is no statutory or regulatory minimum level of business activity that must be conducted in order to meet this eligibility requirement. In determining what is doing business in accordance with regulations will be on a case-by-case basis. So here the government will really look at things like the type of business that you have, and the needs of the organization. So if you own a business and um, maybe you are giving the government as evidence invoices for January 2025 and then August 2025, maybe your revenues are very low and you have little to no employees, and the government likely question whether you're really doing this regular systematic provision of goods and or services. So it would be your burden to show the government that you do meet this requirement, that what you're doing for business is regular. So the doing business requirement does impact the type of petition you will file. We touched upon this a little bit in the previous slide, but if your company is a startup company and you've been doing business for less than 1 year, that means that your L visa would be a new office. With the L-1 visa for a new office, you have a whole year to get that company up and running and then to start doing business. So when you file that petition as the new office, you don't have to have been doing that regular systematic provision of goods and or services yet. Another consideration for the doing business requirement would be where you may have an organization that has been in a legal existence for more than 1 year, but maybe you're still not doing that regular business. So, for example, you might have a U.S. company here that you incorporated a couple years ago. It's just been this passive entity. You have not been selling or doing anything with the business, or maybe the tax returns just show really little, no revenue or little to no revenue. So this wouldn't qualify as what you might say a regular L-1, where you could get that 3-year validity period. But you could potentially apply for what we would call that new office. So you don't have to, again, for a new office, be doing business at the time you file that petition. Doing business, also one thing to keep in mind is that it doesn't mean or it doesn't include just this mere presence of an agent or an office here in the U.S. Again, you do need to show that business activity, and how you decide to show that business activity is up to you, but it is your burden to show the government that your company is actively doing that business. So another requirement is that the employee has at least one continuous year of full-time employment abroad with a qualifying organization within 3 years preceding the filing of your petition. So the employee's prior year of employment abroad must have been in a position that was managerial, executive, or a position that involves specialized knowledge. There are very specific definitions for a manager, executive, or specialized knowledge, and we will discuss those just in a later slide. For the L-1A, which is the manager executive claim, you could be approved for initial grant of 3 years, and then you can renew that visa for in 2-year increments for a total of 7 years. For the L-1B, which is the specialized knowledge position, you can also be approved for that 3-year initial validity period, and then you can renew that one also in increments of up to 2 years for a total of 5 years. So the L-1B, you do get less time. But for both of these classifications, the L-1A or the L-1B, you can recapture time. So for example, if you spend a few weeks or a couple months out of the year outside the United States when you're holding this L-1 visa classification, that time you spent out of the United States can be recaptured. So you do get that 7-year total period, and any time spent out of the U.S., you can calculate that time and file what you might be an extended petition. So showing the government you are still permitted to remain here for the time that you were out of the United States. Just a note on that. So the government does have extensive records on people's travel, but occasionally they don't have that complete record. So it would be your burden to demonstrate to the government that you are eligible to recapture that time you're claiming. Okay, so the new office requirements. So again, a new office is an organization that has been doing business in the United States through a parent branch, affiliate, or subsidiary for less than 1 year. And if the company is sending an employee over here for that new office, there are some additional requirements which we will discuss in more depth here. Okay. So, for the new office, one requirement includes proof that the company has secured a sufficient physical premises to house that new office. The physical premise really needs to make sense with the type of business you plan on conducting, so you just need to keep that in mind. So, for example, let's say you do some sort of import-export business, you need a warehouse to house the goods. Maybe you've conveyed that in your business plan to the government. You may have said, as further example, that you want to hire 7 employees and you may need an office that size to house those people. So if you go to the government, you give them your business plan, you're explaining what you need, but for this requirement for the physical premise, you give them a lease agreement that shows you have 100 square feet of office space and 1 desk, but no warehouse. The government might come back to you and say you haven't satisfied this requirement. So if you indicated in that business plan you needed a warehouse and a bigger office to house these employees, but you're not showing the government you secured a lease that kind of matches what you're stating in the business plan, that can be problematic. So it's important to think about the time of filing, what you're providing to the government, what you're conveying that you will need for that new office, and then also providing evidence supporting, what matches up in the business plan. So regarding the physical premises, just a few more things. This requirement has been more malleable in recent years, especially after the pandemic. But the government does not typically like to see those co-working spaces. So you could receive pushback on an office like that. But however, again, as long as you can demonstrate that it makes sense in light of your business plan, it shouldn't be too big of a hurdle to overcome. Typically, this is not something the government likes to deny on. It's just not a strong argument for them. But unless it's very blatantly obvious that what you're stating is needed for the new office is not met by that lease or whatever you're providing for them. So if you are coming to the U.S. under that L-1A new office to fill a managerial or executive capacity role, your qualifying experience abroad must have been in a managerial or capacity role. So unlike the typical, what you might say, a regular L-1 petition, eligibility for that L-1A new office approval can't be established through qualifying experience involving specialized knowledge role. With the L1A new office, you also don't need to have employees before you apply for that visa, but you do need to show that the U.S. operation will support that managerial or executive position within that 1 year of approval. In my experience, I would say this is one of the biggest hurdles for petitioners to overcome. So you really do um, need to show within that 1 year that your new office will support this managerial or executive role. But in order to determine whether or not your new office will support this managerial or executive position, so the government will want to see things like the scope of your office, the organizational structure, maybe your financial goals of the company, your hiring plan, and then an explanation of how you plan to accomplish those goals, an explanation of when you plan to start doing business, that sort of thing. They will also want to see the size of the U.S. investment, the financial ability of the foreign company to pay the employee or to start doing business here in the U.S. Other things to consider: will the foreign company capitalize the U.S. company? So how will you get this new office up and running? It really does just need to holistically, you need to be able to show that everything lines up and makes sense. So while the foreign company doesn't need to maybe capitalize the entire expenses that the new office would incur, um, you do need to show, again, that it just makes sense. So if you are a foreign company and you're providing to the government your bank statements and your taxes, and maybe you have negative balances, this would be a red flag for the USCIS or the government. I have seen petitions where the foreign company wasn't even solvent. So you could show that they don't, again, need to capitalize the whole amount at the time of filing, but it would be important to show the foreign company could support the U.S. company. So another consideration would be, maybe, will the foreign organization help support the U.S. company with personnel? Again, you don't need to have everyone hired at once. And you could have some of the foreign company maybe support this U.S. company. This would A reason to do maybe this would be just to show, again, holistically, that what you're stating to the government makes sense. So maybe you will not hire everybody at once, and you're going to hire more people later on towards the end of the petition, but maybe in the beginning you have some administrative personnel supporting this U.S. company, and maybe that administrative personnel works for the foreign company. So it is understood, at the beginning when you file that petition, that this managerial or executive role, the person here opening that new business, may be actively involved with the more day-to-day operations, doing some of those administrative tasks in that initial phase of the business. It is important to show that the manager or executive does have the authority, the intent to hire, that sort of thing. But you can show that, maybe you would have some support from that foreign company. It's just the important thing to consider would be at the end of that 1 year that this managerial or executive position really is primarily performing in a managerial executive position, and they have the personnel to support them. Let's see. Okay. So for the L1B new office petition, so again, you can do a new office with the L1B classification. But you would need to show that the person coming over here did serve in what is called a specialized knowledge role abroad for at least 1 year, and that they are coming over here to the U.S. to also serve in a specialized knowledge role. So you would need to show that the person possesses this specialized knowledge, and that the foreign and the U.S. position also involve the use of that specialized knowledge. You still have to show that you have secured that sufficient physical premise, and then that the petitioner has a financial ability to remunerate, pay that employee, and commence doing business here in the U.S. Okay, so as mentioned before, there are very specific definitions for what is an executive manager specialized knowledge role. So here for the executive capacity means an assignment within the organization in which the employee will primarily direct the management of the organization or major component or function of the organization, establish the goals and policies of the organization, component, or function. They will exercise wide latitude in discretionary decision making and receive only general supervision or direction from higher level executives, the board of directors, or stockholders in the organization. So to show and demonstrate the executive capacity, you must show that the beneficiary will perform those certain high-level duties, um, that they will be primarily engaged in those executive duties as opposed to primarily performing administrative or operational tasks alongside like the lower level employees. So one way to demonstrate is to explain to the government, you would really need to provide detailed description of duties for the applicant, the beneficiary, really explaining what they do on a daily basis to meet your burden to show that they are going to serve as an executive. Um, so when you're choosing whether or not to classify your employee or yourself as an executive, you do really want to describe the role in detail, make sure it lines up with that definition of executive. So for example, the definition says that the executive directs the management of the organization. So an executive directs the management of the organization by controlling the work of other managerial or lower level executives. So if you're claiming executive, it's important to show then to the government that there are other managers within the organization that you're going to direct or control. If you provide an organizational chart where you're directly overseeing all the employees that are performing those operational tasks, then the government will likely come back to you and say, there's no management to direct, so you wouldn't qualify for that executive. So it's really important to look at the structure. Again, what you're claiming to the government overall, the petition, how it looks holistically. So typically, if you're claiming executive, you would likely have a multi-tiered organizational structure that you're providing to the government. One other thing for just, when you're describing your duties, your position to the government, it's helpful to provide a percentage of time, how the time is allocated to each duty. This can really help show that the duties are primarily executive. So they focus on that, what is primarily. And then again, you can detail the organizational structure or give detailed description of duties for your subordinates. That will also help show the government who's performing what duties. And if you have people you're explaining that are performing those operational and administrative tasks, and you can show that you would be relieved from performing those tasks because other people are doing them. So just an executive title alone won't be sufficient. You do need to think about the structure of your organization, how many employees you plan to hire and when. Are they there at the time of filing, or how you're going to show at the time of filing that you meet this specific definition of an executive. And if the structure really doesn't support the claim that you are serving as an executive or will be serving as an executive, if your company is really small, then you may want to try for a different category like the manager or possibly specialized knowledge. Okay, so we're going to switch over to Kelly, our partner now, and she's going to discuss in more detail the managerial definition.
Thank you, Katie. So similar to, executive capacity, there is a specific regulatory definition for a manager as outlined here. And there's kind of two paths for a managerial employee. So one would be a personnel manager. So this is somebody who actually manages people, manages an organization, a department. supervises and controls the work of other supervisory, professional, or managerial employees, has authority to hire and fire or recommend other personnel actions such as promotion and leave organization, and exercises discretion over the day-to-day operations. So for this type of of employee, you really need to be looking at that organizational chart and making sure that there is a hierarchy that supports, this argument. So it's not enough to just manage kind of first line employees. You have to show that the employees themselves that are being managed are supervisory, so have people underneath them, or that they are in professional roles, which means roles that require at least a bachelor's degree. Um, the other type of managerial employee would be called a function manager. And so this is where there may not be kind of direct reports. The person may not be, directly supervising anyone or hiring or firing anyone, but they manage a main function of the organization. And it's really key to show that they manage that function as opposed to perform that function. So often what this looks like is that you are in the organizational structure, explaining how there's kind of indirect reports or other departments that help support this person in managing a particular function. You also have to show that they function at a senior level within the organizational hierarchy with respect to this function, and that they exercise day-to-day discretion, over the operations for this function. So this can be kind of a more nuanced argument to make, but if it is a situation where someone truly is, managing a function and has a lot of other, kind of indirect reports or other departments, kind of supporting them in managing that function, this is another, option that can be a good one, if the kind of the personnel management argument isn't there. We can go to the specialized knowledge. Perfect. So for the L1B, this is a specialized knowledge worker, and this can often be the one that requires the highest volume of evidence because what you're showing is that this person has special knowledge, of the petitioner's products, services, research, equipment, techniques, management, or other interest, and its application in international markets, or this advanced level of knowledge or expertise in the organization's processes and procedures. So in either circumstance, you're not only showing that this person has specialized knowledge, but you also have to do kind of a comparison, to show that this specialized knowledge is not held commonly throughout the industry, or is unique in the petitioner's organization. So, specialized knowledge, often going to be, more useful if you have somebody who's maybe been operating in the field for many years. For advanced knowledge, sometimes this can be a good option for somebody that is perhaps, newer in their career, but maybe was really fundamental to the setup of this particular organization. So they have really specific knowledge of the petitioner's processes and procedures. Maybe they were some of the core team developing these things, and that has followed through as the company has scaled and gotten much larger. So sometimes if you have a situation where somebody's again a bit newer in their career, maybe they only have, 4 or 5 years of experience, but all of it is with this particular petitioner, and they arguably have very specific specialized knowledge or advanced knowledge of these processes and procedures that is really important to the success of the company or the commercialization of the company's products. This is an argument you can make to try to, still get an L1B even when the person maybe is not, that experienced in the industry. All right, so let's turn to kind of what documents have to be submitted as a baseline as part of your L1 petition. So one would be the USCIS form. This is form I-129. There's a specific L supplement that gets submitted. You'll also submit a G28 if an attorney is representing you, and if you want to do premium processing to get the government to respond within 15 business days, then you submit form I-907, which is your premium processing form. And then you need to provide all the documentation to show that you meet the requirements. So corporate documents showing the qualifying relationship between the companies, parent, branch, affiliate, subsidiary, proof that each company is doing business, or if it's a new office case, that the US company will commence doing business. So these are things like company tax returns, audited financial statements, lease agreements, invoices, payroll summaries, licenses, contracts. And then you're going to turn to kind of the employee evidence. So that is proof that the employee worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. You're going to include things like the pay stubs, personnel records, detailed job description, organizational chart showing the employee hierarchy. Very, useful if you can kind of back some of this up with work product to show that, what's in the job description is actually backed up by that objective evidence. And then you're going to include proof that the role in the US will qualify as managerial, executive, or specialized knowledge with similar, documentation. It is important to note that you don't have to have the same job, right? So somebody could be a manager abroad and being transferred to be an executive, or could be a personnel manager abroad and being transferred to be a function manager. But if the job is different, then you need to explain how the person's professional background has qualified them to hold this new job. And you need to obviously distinguish it and explain how each individual job meets that criteria. So it can be kind of complicated if, let's say, the person has 1 year of experience abroad, but held two different roles within that 1 year. You would need to actually look at that in detail and make sure each role qualifies as, managerial, executive, or specialized knowledge. All right, we can move to the next slide. So what do you need for an RFE? An RFE is a request for evidence. Requests for evidence are pretty common for L-1 petitions, although RFE rates have dropped over the past few years. There was a big spike from 2019 to 2021 where RFE rates were over 50%, so extremely high. However, recent data in more recent years shows that RFE rates have gone down significantly, more to the 20s and 30s. Most RFEs challenge whether the applicant meets that definition of manager, executive, or specialized knowledge worker. As described in the prior slides, there is just a very specific definition. So calling someone a CEO, if there's really not other evidence to back that up and they're just operating as a solo operator, it's not going to work for an L-1 petition. Similarly, if the company abroad is extremely small, that can be challenging as well. So you do want to make sure that you're planning for this, that just because someone is called a CEO abroad and has, one employee, that's not necessarily, going to make for a strong L-1 case. It is important to have those detailed support letters and organizational charts. You want to include details about employees in the applicant's department, so including their job duties, their professional background, maybe their salaries. Those things can help show that the company structure really does support, the job as executive or managerial. Support letters and charts are most effective when supplemented with objective evidence. So things like work product, emails between, different, employees and staff members, policy handbooks, performance reviews, all of these things are really important. So if you're saying, yes, this person's a manager, they have control over hiring, firing, leave authorization, provide some evidence of that. There should be evidence, that they have the authority to do that, or it's written down somewhere separately from just the employer support letter. All right, so timing and dependence. So the process for the L1 is that first, the L1 petition has to be approved by USCIS. Processing times are several months, but you can pay that additional fee to get a response within 15 business days. This can be an approval, a denial, a request for more evidence, or a notice of intent to deny. If it's a request for evidence or notice of intent to deny, then you'll have that time to submit your response, and then they'll generally issue a final decision 15 days after they receive it. It is possible, like they are permitted, for example, to ask for another request for evidence, but that is more rare. After the petition is approved by USCIS, then the applicant can schedule an appointment at a US consulate to actually get that L1 visa stamp. If they're already in the US, let's say you've entered on a B1 temporarily, you can change your status to L1. Spouses and unmarried children under 21 can accompany the employee on L2 dependent visas, and the spouse is permitted to work. They do have kind of blanket work authorization to work anywhere. The children cannot work, but they can attend school. One kind of caveat to this process is that for Canadians who are applying for the first time for their first L1, they have the ability to go directly to the border and to submit their application to a Customs and Border Protection officer, to adjudicate that at the border. Then if they approve it, that will get sent to USCIS, who will then process and issue an approval notice for the L1. However, for a renewal, even Canadian applicants will have to do that extension directly with USCIS. All right. So, very common question. Does an L-1 visa lead to a green card? There's just kind of a common misconception that, any particular temporary visa will kind of lead to a particular green card. And while that's not the case, that being said, the L-1 does have a common green card that people will apply for. So if you were a manager or executive abroad and you've been transferred to the US to be an executive or a manager, you may be eligible for the EB-1C, multinational manager or executive green card. There are similar requirements to the L-1A, but there is kind of a heightened standard. So if, for example, you got your L-1A, but it was a really tough approval, there was a lot of pushback, you can expect that the transition to EB-1C may similarly be difficult. Additionally, for the EB-1C, the U.S. company has to have been doing business for at least 1 year. So there's not kind of a corollary with the L1 new office with the EB-1C. So if you are planning to do this and you come on a new office, you have to wait until your U.S. company has been operating for at least 1 year before you can apply for the EB-1C. And again, you would want to have, both companies to be quite large, quite successful. It's not required that you have, dozens or hundreds of employees to qualify for an EB-1C, certainly not. But if you only have two employees, it's going to be quite difficult. And this is something to keep in mind that let's say that you were working abroad and you had, three employees and you come as a manager, when you apply for the EB-1C, they will look back at were you a manager? Were you an executive? And that small structure can kind of come back to haunt you. Not to say that it's not possible to get them approved, but it could be kind of a tougher approval, even if you've gotten that L1A. They will look back at that. It is still relevant. It is important. The fact that the company abroad has now grown and is much larger, not to say that's not helpful for your petition, but they will look at what was the structure at the time that you were actually working abroad. Um, the benefit of the EB-1C is there is no labor certification. You get to skip this kind of long labor certification. The EB-1 green card category is also one of the better ones in the sense that it's often current, not as backlogged, not backlogged worldwide, and not as backlogged for, people born in India, or China. So it can be very good from that perspective. The process is that you file a form I-140, and once that gets approved, you can go for your green card. If the category is current, you can concurrently file for an I-485 adjustment of status if you're in the United States, or you can do the process through consular processing. If you are in an L-1A, you do get some benefits. For example, once the green card I-485 is filed, a lot of the time you cannot travel on most visa types, but on the L1, you can travel freely even while the green card petition is pending in the United States. Now, let's say that you want to get a green card, you're on an L, but you're on an L1B, or perhaps you weren't a manager or executive abroad, you were a specialized knowledge worker, and then you transferred to be a manager. In that case, the EB-1C would not be available for you, and you would need to go through another process. So one process might be the PERM process. This is kind of very common. In this process, the company will actually have to test the US labor market, see if there's any willing, qualified, and available US workers who can do this job. And if not, then you can proceed to filing the I-140 and filing the I-485 or the green card through consular processing. There may be other categories that you want to investigate. For example, if the person is, really highly technically advanced, specialized knowledge worker working in an area of substantial merit and national importance to the US, you might consider the EB-2 national interest waiver. But that would be, those would be the ones that are available as opposed to the EB-1C, which is only available when you were an executive or manager abroad and also an executive or manager in the United States. All right. So we've reached the end of the presentation. I don't think we've received any questions. Um, all right, so I think we will close here. Thank you so much, everyone, for joining. Thank you, Katie, for sharing your knowledge, and I hope everyone has a wonderful day.
Bye.